Everyone, welcome. Today we're going to discuss a very important judgment authored by Justice Ashutosh along with Justice Arun Dev, who have concluded that the rights of the original Sikkim population will be protected. The special rights that they get are respect to medical facilities, education, buying land in rural areas of Sikkim, and other privileges. This actually happened because uh, the third generation people who are not original inhabitants of Sikkim, which means these people moved into Sikkim after Sikkim became part of Union of India, and their grandsons now are appealing to court that they need the facilities and the special privileges that Chogyal, who's the original ruler of Sikkim, in 1961 granted to the original inhabitants. But the High Court bench of Justice Ashutosh and Justice Arundev concluded that it can't be done, and the original inhabitants will continue to get those special privileges, and the third generation people who are migrants basically, they won't be given those privileges. So now there is clarity on this issue, and basically this court also held that this is not violative of Part 3 of the Constitution, and if such benefit is given, it will violate the original classification in terms of 1961 Sikkim subject regulation. We're going to discuss the importance of such judgments given by our courts, and particularly what Justice Ashutosh has done. Let me introduce to you my panelists today. I have with me Amit Nayak, who's managing partner of Nayak and Nayak. He joins us from city of Mumbai. Good to see you, Mr. Nayak. I have with me Advocate Sri Venkatesh, who joins us from the city of Delhi. Good to see you. And we have a special guest, the former Chief Justice of the Patna High Court, who actually belongs to Guwahati, Justice Iqbal Ansari. Thank you for joining us today on the show. And we know that you're traveling to the Northeast, but you made time at a short notice. Appreciate your joining us. At the outset, let me request Amit Nayak for his opening comment on what Justice Ashutosh and Justice Dev have done.
Well, first of all, a very good evening to my fellow panelists, and thank you, Tarun. I think it's a very peculiar situation, and I must compliment the division bench of the High Court. But let's set the context right. Who are these people? There are 21 individuals from East and South Sikkim. One, there is a historical irony argument, a constitutional challenge, and what I call is a good faith resilience. That seems to be the case of these people. Having said which, at the single bench, obviously what happened was that the notifications were held to be irrational and violative of Article 14. That's point number one. They quashed the 2006 communication, which held that exclusion of grandchildren as unconstitutional, so they quashed that. And they further held that third generations and beyond are entitled to unrestricted COI on par with categories 1 and 4. So this was the ratio of the single bench. Now, what does the division bench do and how does it set it right, according to me? One, it holds that COI is not a citizenship. So I think that is very rudimentary and goes to the root of the matter. Point number one. 71F, again, that's according cast in black and white. Article 14 test is satisfied. So therefore, it sort of sets aside everything that on all the four counts that the single bench did. And third generation cutoff is faithful, Tarun, exactly what you said, to the 1961 regulation itself. So these are the bases on which the division met. I think it's in the right, it's step in the right direction. Now, what does this mean, Tarun? What does this mean for the families on the ground? You and your parents can use COI for government job applications. That preferential treatment is intact and it is confirmed. So that's the sequitur to this one. Now, the courts say no. Article 371 is being used to justify discrimination. The courts say no. It is being used to protect constitutionality. So I think that's the second one. Why does this matter beyond Sikkim? According to me, this has a domino effect because there are several states beyond Sikkim which will be affected by this. So therefore, I think it's a welcome judgment. 18,000 pending applications, sir. this is the committee route or a real remedy, I think that's really the legal question. The court points to the central government committee, which is constituted in 1989, and the proper form. So I think all these are great. So, in my view, my analysis is that this is legally consistent and the precedent is followed. Again, the precedent in terms of Sikkim versus Surendra Prasad, that's a case in point, restores constitutional clarity on what a COI actually is. And I think there's absolute no ambiguity on this. And it affirms 371F, which I've said before, and draws a principle historically and faithful integrated line. So it makes a clear integration, assimilation between principled, historical, faithful integration. So according to me, that is my analysis and takeaway. And I think it's a welcome judgment, extremely well written, well thought of, and well articulated. These are my opening points.
Thank you, Mr. Amit Nayak, for bringing actually that aspect that it has implications beyond Sikkim. Of course, I'll come to that in the next question. Advocate Sri Venkatesh, I would like to know from you, when you analyze Justice Ashutosh's line of thought behind giving such a judgment, uh, what do you think he's hinting at, in a sense, by doing this? What is the line of thought of Justice Ashutosh behind giving such a judgment?
Thank you, Tarun. So I'll answer that by reading one sentence from his judgment, which I found to be very, very attractive. It reads as follows: Article 14 does not compel the state to erase all distinctions that are integral to a constitutionally protected historical framework. It's very interestingly said. So, what was the case? The case was simple, that Article 371F and the laws that applied to the inhabitants of Sikkim prior to their joining of Union gave certain privileges in terms of education, land, and medical, so on and so forth. So this notification, which was under challenge, effectively said that those benefits, which in the form of a COI identification, would not be passed on to third generation of the original descendants. So this was struck down by the learned single judge in his judgment by saying that, look, this is violative of Article 14. If you gave this to the original inhabitant, you ought to also give it to their descendants. That was really the lump sum and substance of the original view. Whereas in this judgment, the learned division bench has gone into the historically traced the requirement. First of all, it has traced how these original benefits were intended only for the original inhabitants of Sikkim in 19 when the Sikkim became part of the Union in 1975, and then went on to hold that, look, its dilution later on from the third descent, from the third generation, is not a case of violation of Article 14. Very rarely do you find the nuance of or the interplay of the original enactment of the Constitution or Article 371 in this case vis-a-vis Article 14 being decided in favor of a differential treatment. You see that very rarely in the constitutional system of things. Usually, the courts lean towards holding that since you provide a particular set of citizens a set of rights, then those rights are also protected for their descendants on the yardstick of Article 14. Whereas here, the nuance between the original enactments and the original law vis-a-vis these notifications and their application to the descendants has been examined and commented upon, which I find to be quite an interesting read and as a student of law. And it's a very unique play on the whole application of Article 14 in such situations where the original enactment of the Chogyal was meant for a very specific purpose, and that ought not to be continued to the third generation of the original inhabitants.
Venkatesh, one small follow-up questions. The migrants would not be entitled to these benefits. That's clear.
No, there was actually a very broad understanding. My reading is that there was also a scope of naturalization as Sikkim resident. So that would include those individuals who had then migrated to Sikkim and had naturalized themselves. So it was not the idea is to give precedence or preference over Sikkim domicile citizens, but birth was not the only criteria. Even naturalization was one such criteria. I have not examined what really entailed in naturalization as a concept,
So that would,
but the,
but this is
but there
this
was
but this is would be interesting to know, maybe on the next show where we could sort of look for implications in other states. I'll go to Justice Ansari for his analysis.
Uh, Tarun, as far as this judgment is concerned, it needs to be settled by the Supreme Court, and we will have to wait what is the outcome in the Supreme Court. The controversy or disputes as it reflects relates to maintaining special privileges which have been granted to the Sikkimese born in Sikkim and those who migrated on the formation of the state of Sikkim as a part of Indian Union to Sikkim and settled there. Thus, the state's contention was, by state I mean the state of Sikkim, that the privileges which were special privileges, like everybody has said, education, land, and medical facilities, they will not operate in favor of the third generation as far as the migrants to Sikkim are concerned. The challenge was on the basis of Article 14, and the court has turned it down. In a way, court is maybe correct. I'm not sure if it is really correct. Maybe correct in saying that as far as Article 14 is concerned, it does not require the state to remove every kind of discrimination. This will be slightly difficult perhaps to sustain because the Article 14 cannot stand any discrimination as long as, if not as long as, I will say, if those discriminations are not warranted for the maintenance of the state. That is something will be interesting because I don't think we have too many cases on these lines. Because of the birth of Sikkim, there have been cases, and now these cases will have to be gone through and settled by the Supreme Court for all of us.
Point very well taken. So I'll go to Amit Naik from NAC. And NAC, could you sort of develop your argument on implications for other states? Are you sort of basically facilities and privileges given to tribals in some other states or other states like Himachal and Goa? What were you hinting at when you said in your first answer that this may have implications for other states?
According to me, there are similar states. There are states that have a similar provision like 371A. There is Nagaland, there is Mizoram, and others. That's what I was alluding to. And therefore, according to me, this has a wider connotation and an impact on those states as well. And therefore, 370, and I like exactly what Venkatesh said. They've struck a balance between 371, Article 14. It's very rare. You don't see, you don't get to see this, right? And therefore, according to me, it's clearly beyond Sikkim, of course, maybe confined to Northeast and some other states. And that's my take that it will have, because 371A and 371F, like I said, 371A is a function of Nagaland, 371G is for Mizoram. Like the 371F, there are similar and identical provisions, which I think will have an implication.
You will have. I'll go to Advocate Sri Venkatesh for implications on other states and line of thought of Justice Ashutosh.
So I'll tell you, Tarun, basically what happens is that each under Article 371 is a unique provision in our constitution, which actually gives these certain specific states, like, for example, it starts from Nagaland, Assam, Manipur, Sikkim, Mizoram, Arunachal, Goa, and Karnataka. Karnataka, I think only the Hyderabad, Karnataka region. All these unions, princely states which came part of the Indian Union, certain protections have been given. Now, this judgment actually, if at all, if I don't know in facts, will it apply to such states or not, because whether similar notifications have been issued by the state government limiting the benefit of the original inhabitants to the next generation. But should the need arise, then while interpreting Article 14 vis-a-vis these provisions, which is 371A to L onwards, this judgment undoubtedly is would throw some light as to how you are to read such notifications if they are issued in those states. My understanding today is that this problem was acute in Sikkim, because Sikkim, the third generation, was being prevented from getting the original benefits of COI, which the first and second generations got. So to that extent, it will have a bearing, if at all that route is adopted. But largely, it's an interesting judgment just to see an interplay on the limits of Article 14, the limits of manifest arbitrariness. And another aspect of this judgment is that after the Navtej judgment of the Honorable Supreme Court, far and many legislations have been questioned or challenged purely on the ground of manifest arbitrariness and have been struck down also. Some are, in my view, personal view, are rightly been struck down. But nobody has spoken about to the limits of this argument of manifest arbitrariness to strike down a peremptory law or a subordinate legislation. So this judgment actually talks about it and says, yes, even though on the first blush this appears to be manifestly arbitrary, because you are preventing a descendants of original Sikkim inhabitants from getting the benefits of a particular law, a particular regime. But if you understand what the regime originally intended and then see it applied only to those people, manifest arbitrariness as a ground is not available. So this is again an interesting take or an interesting interpretation of that very doctrine, which is used far often to strike down law or at least attack laws framed by the assembly and the parliament.
Point well taken. I'll go to Justice Ansari for his closing comment on this whole issue.
As Mr. Venkatesh has correctly pointed out, though these special privileges are for some of the states for the purpose of their citizens, or it will be necessary for applying this judgment in other cases that there has to be such notification as we're concerned in the case of Sikkim. Because there are two classes of people, one born in Sikkim, their descendants, and those who had migrated into Sikkim on the formation of the state or immediately before the formation of the state, and their descendants. The state has categorized and the court has upheld the categorization that these two categories are not one and the same.
Yes.
As far as the naturalized Sikkimese are concerned, that means those who had moved to Sikkim and then became a part of Sikkim's citizenship and or other state, their descendants will not have the privilege, special privileges which are available to other Sikkimese. Yeah, rather natural born Sikkimese. One thing which we will have to perhaps examine is what will happen to those people who may be descendants of the migrants, but they are now original Sikkimese. Because if anybody is born in the state of Sikkim after its formation, they will be regarded as citizens of Sikkim. Broadly, they were all Indians, but the COI, as they call it, is for the state of Sikkim. As I said earlier, the issue needs to be, and I am sure will be resolved by the Supreme Court. We wish that this controversy is not allowed to foster and be restricted as far as possible by the judiciary.
Point well taken. In fact, that's why I feel that judging is a very interesting, assignment that one gets. People become high court judges for 10, 12 years. But the kind of interesting topics that come off, I have not taken up such a topic where, original inhabitants have moved up and asked, that their rights be protected, or descendants have asked that they should be getting rights at par with original inhabitants. So, these are nuances of society that we get to learn. when, of course, we track the judiciary. I would like to thank Justice Ansari, served as Chief Justice of Patna High Court, now as an arbitrator. Meet Nayak, Managing Partner of Nayak and Nayak, who joins us from Mumbai. Advocate Sri Venkatesh joins us from Delhi. Appreciate your joining us on this interesting topic, and Justice Ashutosh and Justice Dev for authoring this judgment, giving some clarity on this issue for the society and people who are the residents of Sikkim. Thank you so very much for joining us. Thank you.